On October 21st, 2022, the Ho-Chunk Nation Supreme Court handed down a decision that will hopefully awaken all attorneys who work in the Ho-Chunk Nation. Supreme Court Justices Todd Matha, Tricia Zunker, and David Klauser ruled that an expulsion from the Ho-Chunk Nation bar was warranted for former Associate Judge Mary Jo B. Hunter for what reads as egregiously unethical behavior by any person in a position of trust and power. Say nothing of a judge. Now, I'm not going to go into the ugly details, but for cringeworthy reading and for those with a perverse sense of curiosity, feel free to check out case number PR22-01 in the Nation's website. No, what struck me was language in the actual ruling that read, "The respondent is obliged to observe a high standard of conduct." This got me thinking, does this high standard of conduct apply to all attorneys in the nation? I did a little digging, so allow me to share what I found and then pose some interesting thoughts that I think my listeners should consider, especially my enrolled Ho-Chunk tribal member listeners. The first thing I wondered was, do attorneys who work for the Ho-Chunk Nation, do they have to pass a bar exam in order to practice law in Wisconsin? What I found is that if a person graduates from law school in the state of Wisconsin, they are allowed under what is referred to as diploma privilege. As such, they are not required to take an arduous bar exam per se. It appears they are essentially able to practice once graduating with a law degree. A graduate of a Wisconsin School of Law would likely tell me there is a bit more to this, and probably so. But this appears to be the gist of it. I then wondered, are there certain ethics rules that they have to follow in order to practice law in Wisconsin? Now, my unsophisticated search led me to what the state of Wisconsin refers to as the Rules of Professional Conduct for Attorneys. In one passage located within the rules, I read with great interest the following line: "Virtually all difficult ethical problems arise from conflict between a lawyer's responsibilities to their clients and to the lawyer's own interest in remaining an ethical person." Now, this passage goes on to state, these principles include the lawyer's obligation zealously to protect and pursue a client's legitimate interest within the bounds of law. If we take a quick walk down memory lane, recall that I've hosted some podcasts where I discussed my review of the Legislation and Organization Act and the Gaming Ordinance. In each of these instances, I cited what I thought were blatant violations of the Constitution. As we all know, the unconstitutional language in the LOA was removed. That was the language where the legislature tried to give themselves authority over the nation's businesses. Also, in my opinion, there was a great deal of unconstitutional language in the Gaming Ordinance, which still hasn't been codified. Outside of the legislature, nobody has any idea where this proposed law is located within the legislative process. In both of the just mentioned instances, an attorney drafting the proposed laws would have had to weigh their own obligations to their client's interest, in this case, the legislature, against what is within the bounds of law. Let's not kid ourselves. Not a single legislator drafts any of the nation's laws. This is done by their attorneys. I'm forced to pose the question, why wouldn't an attorney risk their profession in drafting a set of laws that they know are unconstitutional and that are not within the bounds of law as the rules of professional conduct for attorneys mandate? After all, according to the Wisconsin Rules of Professional Conduct for Attorneys, they must remain an ethical person. Furthermore, in the Ho-Chunk Nation Bar Membership Association or application, there is language in the certification of applicant section that the attorney applicant signs that plainly reads, "I understand that it is my responsibility to be familiar with the tribal laws applicable to any matter in which I appear as an attorney within the jurisdiction of the Ho-Chunk Nation." I don't know. In other words, in order to pass the bar to practice law in the Ho-Chunk Nation, an attorney must know the law. That seems simple. The legislature has at least one attorney who's worked for the legislature for at least 20 years, Mike Murphy, and another who has probably 7 years of experience. Now, you mean to tell me that attorneys who work for the lawmaking body of the Ho-Chunk Nation are unfamiliar with the Ho-Chunk Nation Constitution? The Constitution is the law of the land, the law of the Ho-Chunk Nation. Now, I understand that if the legislature is demanding radical and self-serving changes to the law, an attorney might feel under duress to follow illegal orders from their client. However, according to Rule 1.2, subsection D of the Rules of Professional Conduct for Attorneys in Wisconsin, a lawyer is prohibited from counseling or assisting a client in conduct that the lawyer knows is fraudulent. Nobody is obligated to follow illegal orders. If they did, in the extreme now, the legislature could order their staff or attorneys to rob a bank. And what? We are led to believe that they had to? It would appear to me that whichever attorney drafted the LOA and the gaming ordinance with all the unconstitutional language may well have placed their ability to practice law in jeopardy because they abdicated their ethical responsibilities and they drafted a set of laws containing illegal language per the Constitution. In the Rules of Professional Conduct for Attorneys in Wisconsin, under SCR 28.4, misconduct, it states, it is professional misconduct for a lawyer to A, violate or attempt to violate the rules of professional conduct, C, engage in conduct involving fraud or misrepresentation, and most relevant to this discussion, F, violate a statute as in draft law that is in violation of the governing document of the Ho-Chunk Nation, our Constitution. Let me say it again and allow it to sink in. It is professional misconduct for a lawyer to violate a statute as in draft a law that is in violation of the governing document of the Ho-Chunk Nation, our Constitution. The law of the land. Simple. People, you've listened to me lament and discuss what I view as a legislature that simply refuses to conduct themselves in a manner that conforms to the tenets put forth by the originators of our Constitution. A major tenet of that is maintaining co-equal branches of government. In my layman's eyes, I see a legislature that persists in a power grab with no genuine concern for the people of the Ho-Chunk Nation. I see no net gains from their actions. And now I see attorneys risking their own careers by apparently committing professional misconduct that could end in disbarment, a death sentence for their career. Attorneys have an obligation to report to the Supreme Court what they see, what may be deemed as unethical behavior. I am hopeful that the Attorney General files with the Ho-Chunk Nation Supreme Court on these potential violations so that the Supreme Court may weigh in and make a message sending decision. The Supreme Court was courageous in disbarring a Ho-Chunk Nation judge for unethical behavior. Perhaps such a hardline ruling will be a wake-up call for the nation's attorneys. We can only hope.